Welcome back to the channel. I'm a barrister who helps you understand law. So you are probably aware, particularly if you've got a vested interest in this case, and it would in any event otherwise be difficult to escape the fact that Amber Heard tried to get this jury verdict set aside. Yes, Amber Heard asked the court, would you please set aside the jury verdict on the basis of some alleged discrepancies with Juror 15? And the court said,
no, the answer is you cannot.
So today we are going to take a little look through that order, denying the motion that this verdict be set aside, and why, if the reasons were not already obvious. And spoiler alert, I for one am pleased that this argument has been brought to a halt and the judge has come to a sensible ruling. So let's take a look at this order. It reads, this cause came before this court upon defendant Amber Laura Heard's post-trial motions. Of course, those post-trial motions be to attempt to set aside the jury verdict. After review of the defendant's post-trial motions, plaintiff's opposition and the relevant statutes and case law, it is therefore ordered as follows. Defendant Amber Laura Heard's post-trial motions 1 through 6 are denied for the reasons stated on the record. Defendant Amber Laura Heard's post-trial motions 7 is likewise denied for the reasons outlined below. The purpose of the voir dire is to obtain a fair and impartial jury. Just pausing there for a moment, I know I've explained this in previous videos, but a voir dire is like a trial within a trial. It is a mini trial of issues to make a determination done by the judge because they want to decide certain things, and in this case, it's the impaneling of a jury. So this reads, the purpose of the voir dire is to obtain a fair and impartial jury. Voir dire is necessary to ascertain whether any juror has any interest in the case or any bias or prejudice in relation to it, and that he in fact stands indifferent in the cause. That is just a long-winded way of saying the juror is going to be fair, impartial, not have any preconceived ideas, not have any relations to the case or people involved, any prejudice or any other reason that they're going to be unfair in the verdict that they come to. We read on. The summons issued to Juror 15 listed in his legal name and address, and no birth date was noted. So just pausing there again, this was a significant point because one of the arguments was about the birth date on the jury panel that was argued over and over again. But the court noted here that the summons issued to Juror 15 was in his name, to his address, and didn't note any date of birth. So arguably, if two people live at the same address with the same name, at the same address, of course, but obviously, unless they're twins, have different dates of birth, that would make a difference. But for the fact that this summons did not have a date of birth noted, we read on. The court has pulled Juror 15's jury questionnaire, attached as redacted, filed under seal. Juror 15 completed the jury questionnaire as himself, filling in his proper birth date. The information presented on the jury questionnaire matches the information Juror 15 provided to the court. Juror 15 was vetted by the court on the record and met the statutory requirements for service. Again, this was important because, as for all of the reasons I've said, and echoing what I've said before and without saying I told you so, it didn't make any difference whether or not this was the correct person intended or whether there was an argument as to whether it was the correct person intended. This particular juror filled in this questionnaire, filled in the information, was vetted by the court, and met the statutory requirements for service on the jury. The parties also questioned the jury panel for a full day and informed the court that the jury panel was acceptable. Again, pausing because this was important because that was their opportunity to object, and they didn't. Therefore, due process was guaranteed and provided to all parties in this litigation. Voir dire was conducted in a fair and impartial manner with the court and both parties examining the potential jurors. There is no evidence of fraud or wrongdoing. Again, pausing to, I suppose, say I told you so, that there would be no wrongdoing in this process because they did go through all of the correct procedure to vet the jury, to vet each member. They had the full day of questioning and this whole process, this voir dire process, to ensure that both sides were essentially happy with the jury and every member that was sitting on it. Therefore, just for emphasis, the court rules there is no evidence of fraud or wrongdoing. We read on. Further, the defendant was provided the jury list 5 days prior to the commencement of the trial, and knew or should have known about the mistake at any time during the 7-week pendency of this trial. Again, pausing there and again echoing something that I've already said, they had a long opportunity to complain about this jury or any one member of the jury and didn't. So this is again the court echoing things that I've already said. She had every opportunity to object to or voir dire on the issue. Again, voir dire being that little mini trial, this legal word for a trial within a trial. So if you get to any point within a trial that you think we need to address this very point, this is an issue that's arisen, we need to decide on it, everything else stops and we have this little mini trial within a trial called a voir dire, which is essentially exactly that, a testing of the facts, the hearing of evidence, the testing of the evidence, judge makes a decision. That decision is then rooted into the main case, the voir dire is over and on we go with the main case, and that's how that works. But it didn't happen. Parties generally must make objections at the time a ruling or order is made to put the court on notice that an issue is meant to be preserved. Despite defendant's assertions in footnote 9 of her motion, Virginia Code clearly states an error in the information shown on such copy of the jury panel shall not be grounds for a mistrial or assignable as error of appeal, and the parties in the case shall be responsible for verifying the accuracy of such information. Noting the embolding of certain words here for emphasis. The court quite clearly emphasizing the burden upon the parties to be responsible for verifying the accuracy of the information, and tied in together with the whole notion under the code that any error in this information is not grounds for a mistrial or assignable as error on appeal. Consequently, defendant as well as plaintiff had an affirmative obligation to ensure the accuracy of the information provided for the jury panel. A party cannot wait until receiving an adverse verdict to object for the first time on an issue known since the beginning of the trial. The issue has been waived. Again, echoing not just my comments, but those of Johnny Depp's lawyers, which is that this has been within their knowledge for the whole time. They cannot simply wait till the very end and say, actually, we don't like the verdict because of this one thing that we could have mentioned earlier on but didn't. We're mentioning it now and therefore want the jury verdict tossed. That's not how it works. Reading on. Even if, arguendo, for the sake of arguing, the objection has not been waived, objections to any alleged discrepancies in juror lists and any legal disabilities of potential jurors must be made in accordance with the Virginia Code. That section provides, in relevant part, unless objection to such irregularity or disability is made pursuant to subsection A herein, and unless it appears that the irregularity was intentional or that the irregularity or disability be such as to probably cause injustice in a civil case to the party making the objection, then such irregularity or disability shall not be cause for summoning a new panel or juror or for setting aside a verdict or granting a new trial. In other words, the court is saying, for the sake of argument, even if parties have not waived their objections, any objections to alleged discrepancies in the jury list must be made in accordance with this rule, which requires that unless it is an irregularity that was intentional, i.e. there was an intentional irregularity, or some other kind of irregularity that is going to cause an injustice, or probably going to cause an injustice in the civil case to the party making the objection, then the irregularity shall not be cause for a new jury, new panel, or for setting aside the verdict or granting a new trial. So again, simplifying even further, if they hadn't waived their objections, any objection must be that the information was either intentionally wrong or it was probably going to cause an injustice. And since it wasn't, they couldn't use it in any event. Furthermore, while parties must make this objection while following the above procedure, the party moving under this code section must provide some evidence of prejudice. Pausing for dramatic effect. Evidence of prejudice. To be frank, there is none. There is no evidence of prejudice at all. Evidence of prejudice would be something along the lines of proof that a juror has got some connection to somebody, been persuaded by somebody, was somehow wrongly sitting on the jury, has been researching the case, has been tipped off for information they shouldn't have had, any other kind of reason or something that would give rise to some kind of prejudice. There simply wasn't anything of that nature whatsoever, and it was simply an argument that it was the wrong person. But that in itself, in accordance with the code, was simply not enough. Defendant has neither followed the proper procedure nor shown evidence of prejudice. Basically what I just said. Defendant does not allege Juror 15's inclusion on the jury prejudiced her in any way. The jury was vetted, sat for the entire jury, deliberated, and reached a verdict. The only evidence before this court is that this juror and all jurors followed their oaths, the court's instructions, and orders. This court is bound by the competent decision of the jury. And there is a footnote with an authority, which is Yellow Cab Court of Abington and Henderson of 1941. And interestingly, the footnote also says that noting that possibilities of prejudice are not sufficient to overturn a jury verdict, and the orderly administration of justice should not be overturned absent a clear showing of prejudice. And so again, in yet simpler terms, this authority provides that it is not sufficient that there is just a possibility of prejudice arising from this juror on any argument that they brought forward. It is not sufficient that simply a possibility of prejudice would overturn a verdict. There needs to be a clear showing of prejudice. In other words, evidence. There needs to be evidence that there was some kind of prejudice, evidence that the overall jury deliberation was somehow compromised by this one juror, by whatever evidence that they had to show, which of course they didn't. There wasn't any evidence at all of even a possibility of prejudice, much less a clear showing of prejudice underpinned by evidence. And so ultimately, this request to set aside the verdict was denied. As many orders do, they provide the decision first and then the reasoning afterwards. So this just provides that the post-trial motions are denied for all the reasons stated therein. And interestingly, and although it's been redacted for obvious reasons because the jury have been sealed for 1 year, the jury questionnaire, which was filled out by each member of the jury, which provided that this juror was self-employed as an IT management in his occupation. So this juror, as the order refers, simply filled out this jury questionnaire, dutifully turned up for jury service, checked all the boxes, that they were a United States citizen, been resident for the last 12 months, and so on. All of these things vetted by the court. The court went through the process to make sure they're not disqualified to sit on a jury, to make sure there's no other reason that they shouldn't sit on a jury, and of course went through the whole process where each side had the opportunity to object and to question whether or not that juror was to be on the jury. And ultimately that process was full and fair, and there is no reason here to suspect any kind of prejudice, much less sufficient to overturn the verdict. And so, as I said in several previous videos, but certainly one on July 9th that I can look at right now, which I will link in the description, this motion has been denied. So you can pop along now to watch what I said before this ruling came out in the video linked below, and in the meantime, thank you for watching.